The High Court rejected initial claim by our client against her mother's clinicians for failing to warn her about the mother's Huntington's disease. The daughter, pregnant at the time, argued that she should have been told about her mother's hereditary condition so she could be aware of her own risk and that of her unborn child, and would have elected to have an abortion. The judge in the original case was influenced by wider implications. Extending an existing duty of care to informing a patient's relatives of hereditary risk would amount to a giant step in law. If such a legal duty of care were established, it could prove burdensome to doctors and damage the doctor-patient relationship. We appealed the decision on the grounds that the rarity of Huntington's disease and the way it is passed down make it a unique example of genetic information predicting outcome. In practice, most patients want to tell their families. Thus, a number of situations likely to arise or be burdensome to individual doctors diminishes even further. Following our argument, Court of Appeal held that it was arguable that medical practitioners could be liable for failing to inform family members of a severe genetic disorder where there is definite, reliable, and clinical medical information, such as Huntington's, that a duty to warn relatives exists. The first step, possibly, towards a duty of care being established in law.